Good evening, everyone. Welcome to another session of the International Malaysian Society of Maritime Law's Evening Talks. On this occasion today, we have a very special treat. Not only because we have a very interesting topic to talk about, but also because we have a very learned speaker to enlighten us along the journey. Today, we will be discussing the recent judgment of the English Court of Appeal in the Eternal Bliss. In the judgment, the English Court of Appeal settled an important point of law on demurrage. In overruling the High Court, the Court of Appeal held that demurrage liquidates the whole of the damages arising from a charterer's breach of the charter in failing to complete cargo operations within the lay time. Accordingly, if the ship owner seeks to recover damages in addition to demurrage, it must prove a breach of a separate obligation. This webinar will touch on the context of that long-standing debate, whether the ruling is justified on principle and commercial realities, the lessons or implications from other common law systems, and the practical implications in drafting demurrage clauses in the future. We have as our guest speaker, Professor Jason Chua, who is Professor of Commercial and Maritime Law and formerly Head of Department at the City Law School, University of London, UK. The professor graduated with a first-class honours from the University of Malaya and held 3 scholarships at the University of Cambridge. He chairs the London University's Maritime Law and Policy Programme and is also editor of the Journal of International Maritime Law. He has published 11 books and over 200 articles in academic and professional journals. His works have been cited by tribunals and institutions in the EU, US, the UK, and Asia, including the House of Lords. So without further ado, I hand the stage over to Professor Jason Chua.
Thank you very much, Mr. Pandian, for those very gracious words of introduction and welcome. I should also like to take this opportunity to thank Mr. Jeremy Joseph and the IMSML for reaching out to me and extending this very gracious, kind invitation to speak. As a Malaysian living abroad, this opportunity to connect virtually, albeit, with fellow Malaysians is a little like bagai ikan pulang terluka. Of course, I'm also very grateful to the many non-Malaysians who are joining us today. I hope that through this short webinar and the discussions that follow, that we will both find the session edifying and to our satisfaction. Right, moving on to the thrust of today's subject matter, and I'm going to share my slide with you. Just let's see how this works. Okay, so I hope you can see my slide presentation. Thank you, Clive. So the subject matter concerns a vessel called the Eternal Bliss, the picture of which is before you on this screen. And it touches on a very important practical area of law in shipping, but it is also of some degree of importance as a matter of commercial law outside the shipping sphere. And I want to touch on that today. So the scope of my talk today is really just to introduce to those of us who are joining us today, who may not be entirely au fait with the concept of demurrage, what it means, first of all, and then to touch on the problem that we encountered in the case called the eternal bliss. Then I want to comment a little on the solutions provided by the High Court and subsequently the ensuing decision in the Court of Appeal that Mr. Selvapandian alluded to in his introduction. But crucially for us, I want to spend a little bit more of our discussion time on the implications for 4 domains arising out of this decision. First, the implications this case throws out for doctrine, for practice, for policy, and of course, given the fact that many of us in our midst today are from various common law jurisdictions across the globe, the implications of this particular decision for other common law jurisdictions. So very quickly moving on to our general introduction as to what we consider in law to be the concept of demurrage. Now, if you go back far enough, you will realize that the concept of demurrage at one time was extremely controversial. It settled down a little bit, but despite it settling down, it never really was able to deal with all the various challenges that have arisen around the law relating to remedies. So perhaps as a start, let's take an example as to where demurrage comes in and why it is important. So for those of us who are in the know, a charter party is essentially a contract for the transportation of goods by sea. And this charter party will normally contain in it a requirement that the charterer, that means the person who is using the vessel, the person who had taken on this contract for the use of the vessel, there is usually a requirement that they must unload the ship or load the ship within specified time. If they hold the ship for longer than they are allowed to under the contract, then they have to pay a sum of money. This sum of money is what we call demurrage. The period of time that you take for loading and unloading, which is provided for in the contract, is called lay time. The two concepts are, of course, interrelated, as you can see. Contract would set up a time within which you should load or unload. If you exceed this period of time for loading or unloading operations, then you must pay demurrage. Demurrage being a sum of money. Now let's then move ourselves away from practice into the law, into jurisprudence. This sum of money, how should we characterize it in law? Now, in some older cases, the courts had always taken the line that this is a mere payment for the use of the ship. So imagine this. If you hire a car from KLIA, that is Kuala Lumpur International Airport, for 5 days, but because of an unforeseen event, you want to extend your period of hire, but you do so without telling the car rental company. So you use it for 7 days instead of 5 days. Now, when you return the car at the airport about to catch your flight back home, the rental company says to you, you've exceeded the period by 2 days. Now you've got to pay 600 ringgit. What is that? What is the nature of that amount of money that you are paying? are you simply paying the rate for the use of that car in excess of the agreed period? That is, say it is a mere payment for the use of the vehicle. Or is it, as some might characterize it to be, a sum in liquidated damages? Now, as you know, liquidated damages has had a rather checkered history. We know that the common law has always had a certain suspicion, has had a certain lack of trust over this idea of agreed damages. For example, we find in some older cases that if you had an agreed damages provision in your contract, that could be seen as an exclusion by the parties of the judicial powers of the court. Because you're saying essentially that we will take the power away from the court and we will decide what kind of agreed damages should be paid. There is also a doctrine that individuals, private parties, are not allowed to impose penalties on each other, because the notion of penalty connotes this idea of punishment, and the idea of punishment has to be one that should only be exercised by the state. And so agreed damages, if they cross the line into what we consider to be penalties, if it is too exorbitant, if it is too oppressive, if it is too harsh, then the courts would say this is not a fair representation of an estimate of the damage that we suffer, but instead this is a sum in terrorem, that is to say, a sum which seeks to terrorize the other party. And as such, it will be deemed as a penalty and would not be enforced. Now, this starting point is really quite important. So we have two strands of thought in the early periods of the development of the concept of demurrage. On the one hand, we have this notion that demurrage is merely a payment for the use of the ship. On the other hand, it is a sum in liquidated damages. That is to say, it is a provision dealing with the party's own estimation of what damage might have been encountered or might have been sustained as a result of the breach. But we now know that there is a much firmer position taken, and this more firm position states that demurrage is indeed a sum of agreed damages. So it is a matter of liquidated damages. But what is interesting in all this is the fact that because the law on demurrage has developed almost in a sense autonomously, without particular reference points within the general development and evolution of English commercial law, we find that there are two sets of authorities. Those cases that relate pure and simple to demurrage in shipping, and those cases that relate to liquidated damages clauses in a more generic, in a more general sense. Now, the question we found in the kernel of Bliss was, in a sense, a structural one. Can you, when dealing with a demurrage clause, borrow from the law and the cases referring to liquidated damages? That was a tricky question. Both the High Court and the Court of Appeal took the view that you should really try and only look at the law, the case law on demurrage, and you should not look to the case law dealing with liquidated damages clauses in a general commercial sense. Now, this has not really been picked up on because at some level, I think there is a general consensus that this is probably an appropriate solution. But I want to point out afterwards that actually what the Court of Appeal has done in this case might actually be to bring demurrage back into the fold of liquidated damages clauses in a more general sense, and actually perhaps to some extent the notion of demurrage being sui generis, being unique, being special, might actually have been lost. But let's look at that later on. So what was the challenge that we found in the eternal bliss? But before we do that, let's, for those of us who have not encountered demurrage clauses before, let's take a look at the demurrage clause which was in issue in the eternal bliss. Now, the demurrage clause in that case is pretty standard. They're all generally quite standard, okay? So essentially it goes like this. It says that demurrage, if it is incurred, that is to say, if you exceed the period of time you were given to load or unload, then demurrage is payable at a maximum of 20,000 US dollars per day or pro rata, and so on. Okay, so this was essentially the demurrage provision in that contract. So you have to pay this amount, 20,000 per day, over a certain period of time. So the problem in the eternal bliss was a little like you taking this car in excess of your 5-day hire period. But unfortunately, there were a few problems with this case, the facts in terms of what the ship owners were encountering. So this ship was unloading soybeans in China, and unfortunately, this is becoming a bit of a standing problem, and that is that of port congestion. Across the world, as you know, logistic chains are seriously prejudiced because of port congestion. There's a problem which will remain with us, and worse after COVID, with this increase of demand for goods, it's going to get worse. And this is why, although this is a case relating to private law, I put it to you that it will have serious and significant policy implications, which we'll touch on later. So as a result of port congestion, the ship was kept at anchorage for 31 days. That's very excessive. Now, of course, you also know that soybeans are perishable goods. So true to form, they deteriorated and they started to cake. It means they could not be used for human consumption. So they were spoiled, and the ship owners had to pay a claim. And this claim was settled at 1.1 million US dollars. Now they then claimed demurrage. Now this is particularly interesting. Now, of course, you would expect them to claim demurrage, the 20,000 per day in excess. Yeah, oh, they claim all that. But because the cargo had deteriorated, they argue that they should additionally be entitled to damages for the cargo loss. The charterers turned around and said, no, 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 no. You have an agreed damages clause. The damage to the goods, the deterioration of the goods, was a direct result of the ships sitting in anchorage. It is a direct result of the ship's detention. It is the same breach. It is the same problem. It is the same cause. And as a result of that, your demurrage claim must cover everything. And in legal jargon, they would say demurrage must liquidate the entire claim arising out of detention. Now, this is a particular challenging case because we don't actually have a very clear-cut position in law as to whether this agreed clause only applies to some parts of the consequences of the failure to complete cargo operations in time, or whether it would allow you to extend it to the entirety of the consequences. Now, Mr. Justice Andrew Baker at the Court of First Instance was quite right to say that from time to time, a case provides the opportunity to resolve a long-standing uncertainty on a point of law of significance in a particular field of commerce. This is such a case. So let's take a look at the High Court decision. And I don't want to go into too much of the case law that was cited before the judge. Fascinating the case law might be, given the fact that I'm fully aware that a good number of our audience today are not from the legal fraternity. But essentially, the court was introduced to a number of cases, and none of those cases is directly in point. There were a number of construction cases which were directly in point, but remember what I said earlier? The court said we cannot be guided by these construction cases because demurrage is a very specialized, a very unique area of jurisprudence. So those construction cases were also shown the door. There was only one case that the court had to contend with, and that case is called the bond. Now, in the bond, what the court decided there, a High Court decision, what the High Court decided in the bond was that when you have an agreed damages clause, it will cover everything that arises from the detention of the vessel. That means the owners cannot make a claim for this extra bit of cargo deterioration. Now, Mr. Justice Andrew Baker considered the bond and essentially held that this case was wrongly decided. And of course, within the doctrine of stare decisis, or binding precedent in England and Wales, one High Court is not bound by another High Court decision. And so Mr. Justice Andrew Baker took the view that we do not need to be bound by the bond. The bond was clearly wrong, and this is why it is wrong. The court said this. Now, this is particularly important. The court say that agreeing a demurrage rate gives an agreed quantification of the owner's loss of use of the ship to earn freight and nothing more. It does not measure or touch on any claim for different kinds of loss, which means that the court said if the loss relates to the loss or the failure of the ship to earn freight, that is covered by demurrage. But if there is something else and that loss is different, then you can claim additionally for that loss. So what the court therefore did was to say that the owners, the ship owners, can claim both demurrage as well as the cargo loss or the cargo deterioration, because the cargo deterioration had nothing to do with the ship's capacity to earn freight. This is a particularly interesting qualification or complexion that the court has given the notion of demurrage. Now let's transport us back to the introduction slide. Do you remember at the introduction, we say that demurrage might be one of two things: an agreed damages provision or simply an agreed sum for use of the ship. Okay, so one is seen as a remedy, one is seen as pure payment for use. But here the courts say that it is an agreed damages clause, it is liquidated damages, but it is not liquidated damages for everything that arises out of the ship's non-contractual detention. It is specifically tied to the ship's capacity to earn freight. Now, this is a very, very interesting development as far as case law goes. Okay, so we now clearly see that the High Court had taken a line that we want to change things. I'm going to pause here for a while because I want you to reflect a little on the fairness or justice of this case. Now you can see that the owners had suffered a lot more than just $20,000 a day late. Yeah. That $20,000 per day late, is not going to cover the 1.1 million as well as the loss of freight. So you could see why they wanted to claim for both demurrage as well as the cargo deterioration claim. On the other hand, for the charters, they say, well, this charter party is your contract, it's your standard form, it's your template, and you must therefore live with the consequences of what you yourself have engineered. If you had written this contract for me to sign and I have very little say in the matter, then why should you be allowed to resile from it now? So you can see that here we have, in a sense, the substance of the problem. Okay, let's see what the court in the bond held, which was, of course, as I said, the only one clear authority on the matter. Now, in the bond, it was also a case of bulk cargo. And you have here, however, a demurrage clause not in a charter party, but in a sale contract. So you can see that demurrage clauses tend to have this sort of back-to-back character. So the owner of the ship, the charter of the ship, they'll have a demurrage clause. Then if a bill of lading is issued, that bill of lading will also have a demurrage clause. And then because the seller, if the seller is the shipper, wants the buyer to take on board the risk of covering for late loading and so on, then there will also be a demurrage clause there. Either way, yeah. So you can see how the demurrage clause is transposed from one legal relationship to another. But crucially in this case, as we can, the facts are very similar. You have got delay, and as a result of the delay, the buyer had to pay extra carrying charges. Question is, can these carrying charges be claimed? Now, the court held in that case, as we said before, that no, if you have a demurrage clause, that demurrage clause will liquidate the entirety of all your consequences arising from a single breach. Right, so moving further into how the Court of Appeal addressed the issue. Now, the Court of Appeal decided largely without really going too much into the nitty-gritty of the jurisprudential arguments, was particularly concerned that the bond is an authority for the shipping industry, not only in the UK, but across the world for around 30 years. Incidentally, that was about the time I started teaching. It was decided back in 1991. And because it had withstood the test of time, the court was very reluctant to open up to Mr. Justice Andrew Baker's decision, which would create a new deliberation, a new proposition for the law. And the court felt that unless the bond was clearly wrong, it should not be overturned. And there was no reason to suggest that the bond was clearly wrong. Many of the authorities in demurrage, were clearly unclear, but they did not render the bond incorrect. So that was a crucial reason that the court gave. But there was also a policy point that the court touched on, and it was this, that ship owners tend to have P&I cover for cargo claims. But charters don't. Charters do not belong to P&I clubs. And they don't take out special marine cover for any demurrage or cargo claim losses against cargo interest. They have to rely on the demurrage clause. This is where the back-to-back thing is. Remember, as I said to you, you've got a charter party, which concerns the relationship between the owner and the charter, and then you got a bill of lading contract, which concerns the relationship between a charter and a normal consignor of goods. Now, in that relationship, if the consignor was late, if the consignor had detained the vessel, the charter would have to pay demurrage to the ship owner, but they claim the demurrage from the cargo interest. But if, let's say, the cargo loss was the result of the detention, the charter is responsible to the cargo interest for that without the benefit of insurance, and they had to rely on demurrage. So the court said, therefore, if you change the rule in the bond, then you will put the charters in a much weaker position, because it is not conventional for them to get P&I cover or insurance cover for cargo claims. And of course, the court also made and stressed the point that in the end of the day, if you don't like your demurrage clause, draft a different one. That is always available to you. So let's then wrap this up with a pure statement of law then. The pure statement of law is essentially this, that demurrage will liquidate all losses arising from the detention of the ship. And for any extra consequences that the owners wish to seek damages for, they have to prove and show the breach of a separate contractual obligation. And to say that obligation must be one that is not simply the detention of the vessel. Okay. Now let's then quickly move on to the reflection that I have in terms of this decision. So I've given myself about 10 minutes or so, 15 minutes at max to look at some of these implications. So the first that I want to delve into is the implications for doctrine arising out of the Court of Appeal's affirmation of the rule in the bond. Now, looking at that decision, position whereby demurrage liquidates all consequences arising out of detention, what the court has done is to bring the law on demurrage much closer to that of general standard liquidated damages clauses in broad commercial law. Now, if that is indeed where demurrage clauses have been taken into, remember I say to you, the Court of Appeal took the line that, these construction cases are not terribly helpful, but actually the net result is to say that, well, they should be treated like that. Now that means there is now this matter of how liquidated damages clauses have developed in the common law. That body of jurisprudence is likely to have an impact on demurrage clauses. Up until now, I have not seen a single demurrage case that deals with this new test that the Supreme Court laid out in a case called Cavendish and McDessie on ascertaining whether a clause in question is a liquidated damages clause or a penalty clause. In Cavendish's case, the court took this view that, at least the majority of the bench took the view that the fairness, the non-penalty flavor of the clause must be assessed looking at whether that clause sets out to protect the other party's legitimate economic interest. Now, this test, which references looking out for the party's legitimate interest, is an interesting one, but it's not been discussed in any of the demurrage cases. So this new test that the Supreme Court introduced is going to be quite, I suppose, would be challenging when being applied to a demurrage context. So what we see, therefore, is to some extent the development of a new framework for assessing the fairness of a demurrage clause. That's not to say the outcome is going to be different, but the test looks different. Now, this also suggests, therefore, that it should be reasonably possible to borrow case law from other economic sectors, like construction, where agreed damages clauses are usually quite pervasive. But because of their power, because of their reach, we have also seen agreed damages clauses, liquidated damages clauses, being tested as unfair terms in contracts. Now, that's something which has also not arisen in the law of demurrage. So all these are going to be, to my mind, at least as an academic, could be interesting / controversial / challenging notions to accommodate as we evolve the law relating to the demurrage further. So my concern slightly, that is not to say I disagree with the Court of Appeal decision, but my slight niggle is whether we have created perhaps a texture of uncertainty, a texture of doubt as to the correct test to apply to demurrage. Now, what about practice? Are there any particular implications for those of us who are in non-contentious work? So the Court of Appeal say, yes, you could draft your own if you don't find your demurrage clause to be all-encompassing. So let's take a look at this first one, which was something that an acquaintance of mine ran past me not long ago, when the High Court decision in the Eternal Bliss first came out. They say demurrage, if incurred, to be paid by the judges. The parties agree that demurrage is not in substitution for any and all other rights and remedies provided by law or otherwise for any breach of lay time and other terms of the Charter. Okay, so from a pure English law point of view, this is a clause that is not negated outright. It will have to be tested using standard rules of construction of contracts. But I want you to perhaps reflect a little on those legal systems sharing the same common law heritage, which may consider this to be perhaps a clause that is to condone or to forgive a fundamental breach, or that it could be seen as bordering on being unfair and one-sided and unreasonable. So those are particular challenges for us to think about if you are looking at advising ship owners and charterers vis-a-vis the drafting of demurrage clauses, if you want to avoid the consequences in the Court of Appeal decision. On the other hand, if you were the owners and you want to make clear that the demurrage covers everything, then you might want to try the second option on the slide, which is that the parties agree that payment of demurrage shall be exclusive and in substitution for any and all other rights, ... Now, this clause is actually pretty standard as a liquidated damages clause, but it is not usually framed in these terms in the context of demurrage. So the crossover is already something that people are putting on the cards. So, of course, drafting one set of agreement, one set of legal relationship is not the be-all and end-all. Remember the back-to-back system of international trade. So if you have it in your charter party, you may need to consider how it fits in the bill of lading contract. And then people in international cells will need to think about how that demurrage clause would fit in their FOB contracts or their CIF contracts, etc., etc. So this back-to-back thing is also going to be a little bit challenging because in the past, people have not really thought much about it, simply to mirror these provisions down the food chain. Then the insurance point is also an interesting one. Should charters now consider taking out insurance for unliquidated damages claims if, let's say, you have a clause like the first one, whereby demurrage is not exclusive? So some thoughts for us, and I'm more than happy to take questions afterwards. Thoughts around implications for policy. Now, there is also the converse. In the Eternal Bliss, we saw that there were two losses, right? Ship was delayed by 31 odd days, and cargo had deteriorated. There were two specific losses. The package of the loss was very big, and the demurrage didn't cover it. But it is conceivable that demurrage might actually be more generous than damages. Yeah. And so if that is the case, then actually just claiming for demurrage would be quite appropriate. But of course, if that is the case, then you run the risk of the charters trying to repel your attempted enforcement of the Demurrage Clause, arguing that the demurrage being so generous might essentially be a penalty. There is also an emerging challenge for us to think about. Now, research in various scientific journals out there tells us that hull fouling in long periods of anchorage, especially in tropical waters. So, the waters in Southeast Asia, temperature, sea water temperature has risen, as you probably all know. And if a ship were to sit in Port Klang in anchorage for a long period of time, the hull will start to accrete various organic and organism growth. Now, this, however, will reduce fuel efficiency. And given where fuel prices are today, and they're shooting sky high, $96 a barrel, the last count. Don't forget, not long ago, it was only $40 a barrel. $96 a barrel. Now, this kind of loss may not have been anticipated by the ship owners when the ship owners first hired out the vessel or chartered out the vessel. So the $20,000 per day late might not cover it all. But if the bond has been now confirmed to be correct, the Court of Appeal decision in the Eternal Bliss means that this kind of losses for reduction in fuel efficiency, given the green agenda, cannot actually be claimed in addition to demurrage. So think about that. Also, does it help towards the global problem of port congestions? This decision clearly favors the charterers. You must bear in mind that the charterers are usually the person responsible for the operations of loading and unloading. So you've got to set, therefore, an appropriate level of deterrence in your demurrage clause to ensure that there is efficacious loading and unloading, so that this problem of port congestion and bottlenecks in supply chains could be controlled and better managed. And last but not least, I hope I've got a little time left. I will spend no more than 2 or 3 minutes here, and then we'll pause for questions and answers. So what about implications for other common law systems? I think there are 2 things here that I like to point out. The first is a very broad-ended one, and that is the reception of English law. Now, the bond is a case decided, as I said, in 1991. 1991. Many of the other cases were decided much earlier on at the turn of the 20th century, which means before the period of independence of many former Commonwealth colonies and protectorates. So this means that the bond is not binding precedent, is in a number of former colonies. But there is also an added problem. Now, as you know, in Malaysia, the reception of English law works in 2 ways. You've got the reception of English law in terms of general civil law, and that has a cutoff date in 1956. So anything post 1956 from England is not necessarily or intrinsically part of the common law in Malaysia. However, there is a special provision relating to mercantile law or shipping law. In shipping law and mercantile law, there is ongoing reception And this ongoing reception raises the challenge for us. That is, if demurrage jurisprudence is mercantile law, then there is this continuing reception of English case law relating to demurrage. But if demurrage is no longer or is not to be treated as strict mercantile law, but general civil law of contract, then there is a cutoff, isn't there? So that is something that applies not, of course, only in Malaysia, but in various other Commonwealth jurisdictions. And last but not least, this idea of a demurrage now being brought back into the liquidated damages family, it will now be exposed to the challenges around the rule against penalty. In the UK, in England and Wales, as I say, we have moved the discussion a little bit further, and we have now a new test. But in some jurisdictions where you have the Contracts Act of 1950, say in Malaysia, you still have to rule against penalty there, which is very much based on the case of Dunlop pneumatic tires, for example. So that old test would still apply. So I think these are particular challenges for us to reflect on. So with that, I just thank you for your attention and your forbearance. You've been a very, very good audience. Thank you so much. And I'm going to pause now and pass the floor back to Mr. Selvapandian. Thank you.
Thank you very much, Professor, for a very clear exposition of the judgments of the Court of Appeal and the High Court. I thought I will pick some of the questions from the Q&A in the chat, and hopefully the professor can comment on them. The first question is from Bhavik Rajni, where she asked that, does the eternal bliss judgments impact on demurrage clauses in sales contracts, for example, CIF contracts? And also, occasionally sales contracts are concluded earlier than a voyage charter party and can differ from the rates in a charter party. If they are higher than the charter party demurrage rates, can this then be treated as a penalty, referring to the demurrage clauses in the sale contracts? You're on mute, Professor. Sorry.
Thank you. So the question is, does the eternal bliss impact on demurrage clauses in sales contracts? I think the short answer is probably yes. The reason for that is because the court turned to the bond and confirmed that the bond is a sound decision despite various misgivings, and of course the bond relates to an FOB contract, and therefore I would say by extension it would also apply to sale contracts expressed in different Inco terms such as CIF, CFR, and so on. And what was the second question, Mr. Selvapandian?
It was whether in the occasion where sales contracts are concluded earlier than a voyage charter party, can and have different rates, different demurrage rates than the charter party, can the demurrage rates in the sale contracts be held to be a penalty?
So what you will have to look at, and this is a very tricky area of law. So you have got two contracts. You've got the sale contract, you've got the voyage party, and so it depends on whether you already pre-agreed in the sale contract what your rate of demurrage is, and then you have a charter party with a different rate. So whether the court would consider the demurrage clause in the sale contract as being enforceable or being fair or not depends on what the rate is in the actual charter party. So that has some impact. I remember that up until now, because we treat demurrage clauses quite differently to liquidated damages clauses, they do not need to be an accurate reflection of the loss. And so this means that Of course, I mean, I'm speaking in terms of English law because I'm aware that in other jurisdictions, the penalty rule is much more strict, yeah? So in the context of English law, the demurrage clause in the sale contract will be assessed within its own four walls, but the reference would be made to the demurrage clause in the charter party. And if there is a violent difference between the two rates, then there is a suggestion that the demurrage clause in the sale contract is one that is in terror and not a liquidated damages clause, not a genuine pre-estimate of the loss. But as I said, there's a lot of room to maneuver because the Cavendish's case, if that applies, and the Supreme Court took the line that we need to give people the opportunity to set this broad range, whereby as long as it's done in, sort of a reasonable expectation of protecting their own legitimate interest, that should be fine. So if, let's say, the violent disagreement is about, or not violent, but let's say the disagreement is, say, 20%, I think the court would say that's okay.
Thank you very much, Professor, for taking the questions. Yes, the slides will be available to participants after the talk. And I think that just brings us up to the hour. And it will be time to wrap up this evening conversation on the judgments of the eternal bliss. I would like to thank Professor Chua again for his time and for making himself available and for answering all our questions today. Thank you very much, Professor. I hope you will pay us a visit when you're down in Malaysia. We look very much forward to seeing you. Thank you very much, Professor. Thank you very much, everyone, for your time. Thank you very much.
Thank you. I can see there are one or two more questions there. I will type a response, and for those of you who want to have a look at the response, then by all means stay on the chat. Would that be okay?
That will be fine, Professor. Yes, go ahead.
Okay.
Yes.
So thank you so much, and thanks for the very kind invitation. I feel very gratified to have been involved in this. Thank you very much.
Thank you very much, everyone. Thank you very much.